Welcome back to the Law on Partnerships and Private Corporations. We now proceed to the next part of our discussion, which is the obligations of the partners among themselves. But first and foremost, let us discuss what is an obligation. Let us first discuss very briefly the concept of an obligation. Obligation is defined in your civil code also, specifically in Article 1156, which defines an obligation as a juridical necessity to give, to do, or not to do. Okay? So when you talk about an obligation, basically there are two general parties involved in an obligation. You call the first party the debtor, and the other party the creditor. Specifically, the debtor is the one or the person who must give, do, or not do the obligation. On the other hand, the creditor is the one who has the right or who can demand the performance or who can demand the object which is the subject of the obligation. So again, there are two principal parties involved in an obligation, the debtor and the creditor. We now proceed to discuss the first obligation of the partner among themselves. And the first obligation in this regard is the obligation of a partner to contribute his or her share in the capital. Now, if you recall, the definition of a partnership involves the partner contributing money, property, or industry to the partnership. And under Article 1786 of the Civil Code, every partner is considered a debtor of the partnership for whatever he may have promised to contribute thereto. So if he or she promised to contribute money, or to contribute a certain property, or to work for, or to render services for the partnership, then the partner is considered as the debtor of the partnership. And then the partnership, as we have discussed earlier, becomes the creditor of the partner. The partnership can then demand the performance of the service or can then demand the payment of the money or the turnover of the property which may have been pledged or which may have been promised by the partner. Related to a partner's obligation to contribute his or her share in the capital is the partner's obligation to be bound for warranty and to be liable for fruits. That can be found in Article 1786 of your Civil Code, which specifically reads as follows: He shall also be bound for warranty in case of eviction with regard to specific and determinate things which he may have contributed. He shall also be liable for the fruits thereof from the time that they should have been delivered without the need of any demand. Now take note that the partner's obligation to be bound for warranty and to be liable for fruits refer only to specific and determinate things. Now you may have learned this in your class on obligations and contracts, but to recall, specific and determinate things refer to things which are particularly designated or physically segregated from all the others of the same class. Meaning to say you can pinpoint that particular thing with specificity or particularity. You can determine which one you are talking about, which one you are referring to. The thing has become specific and determinate in that regard. Again, related to a partner's obligation to contribute his or her share in the capital of the partnership, the partner also has the obligation to be liable for interest and damages. Now, when is a partner liable, or when can a partner be held liable for interest and damages? Article 1788 tells us the answer. It says there, a partner who has undertaken to contribute a sum of money and fails to do so becomes a debtor for interest and damages from the time he should have complied with his obligation. In other words, aside from the money, or aside from the sum, the principal amount involved, which the partner pledged to contribute, aside from that principal sum, the partner also becomes liable for interest and damages over and above, or different from, or separate from, the principal amount which he or she has pledged to contribute. Now, one important point regarding a partner's contribution of his or her share in the capital, we must take note of Article 1790 of the Civil Code, which says that unless there is a stipulation to the contrary, the partner shall contribute equal shares to the capital of the partnership. So again, the thing that we must look at regarding the contribution, we must look at the stipulation. We must look at the contract. Ask ourselves, does the contract say anything regarding the contribution of each and every partner? And in the absence of any stipulation in that contract, then we presume that the partners contribute equally in terms of the capital of the partnership.